Planning to get a work visa in the US in 2026? Let's talk about how this actually works. Because when it comes to working in the United States, not all visas are the same. And choosing the right one is not just about eligibility, it's about strategy. Hi, I'm David Keller, an immigration lawyer, and Keller Law Group is very successful with work visa cases. Nothing is more clarifying than understanding the differences and specifications of these various work visas. Number one, there's an H-1B visa. One of the most common pathways is the H-1B visa. This is an employer-sponsored visa, which means you cannot apply on your own. You need a company willing to sponsor you. And in many cases, it goes through a lottery system. This means even if you fully qualified, you still may not be selected. It's typically used for specialized roles, jobs that require a degree, and corporate positions. But here's the key point. Your status is tied directly to your employer, and that's where things can get complicated. Another option is the O-1 visa. This is for individuals with extraordinary ability, and this is where many people are misunderstood. You don't need to be world famous, but you do need to show strong achievements, recognition in your field, and a level of expertise that stands out. The advantage here is there is no lottery, but the challenge is you must clearly prove your qualifications through documentation. So this is not just about what you've done, it's about how your achievements are presented and supported. Number three is the EB-2 NIW. This one is different because the EB-2 NIW is a green card category, and in some cases you can apply without a job offer. But instead of employer sponsorship, you must demonstrate that your work benefits the United States. This includes showing that your work has national importance and that you're well positioned to advance it. And this is a very strategic process. It's not just paperwork. It's about building a strong case with evidence and positioning. This process is complicated and sometimes a bit longer, but it has lots of benefits when everything goes right. And more importantly, you're not tied to a job or an employer, but documentation and preparation is essential. 4. There's the L-1 visa. The L-1 visa is for intra-company transfers. So if you work for a company abroad, you may be able to transfer to a US office. This can be a more direct path, especially if your company already has a presence in the United States. But again, your status is tied to your job. Now, let's understand what happens if you lose your job and your visa status is tied to it. This is a very important question. Your answer depends on your specific visa type, but in many cases, they have a very limited grace period. And during that time, you either need to find a new employer to sponsor you, change your status, or take action to protect your legal situation. Because if no action is taken, you could fall out of status, and that can create serious immigration consequences. So this is something that should never be ignored. When it comes to work visas in the US, there is no one-size-fits-all solution. Your path depends on your experience, your career, your goals, and your timeline. And choosing the wrong option, well, can delay your process or even limit your future opportunities. That's why strategy matters just as much as eligibility, because the right decision today can shape your entire future in the United States. To know more about US immigration, subscribe to this channel and follow Keller Law Group on all social media platforms. If you think you fit one of these descriptions we covered, please contact our office and let's understand the best path for your immigration journey.